those who advocated for or would still advocate for sodomy laws or laws of that sort make a moral argument. I believe a lot of the amicus briefs submitted in this case made a moral argument about homosexuality itself, and kind of like it's always been this way, and therefore we've always understood homosexuality to be morally bad, and therefore that's why we have this law, and that's why the law should stand. Something like that. I'm grossly oversimplifying.
No, I don't think actually you are.
Okay, maybe I'm not.
I think that's pretty close to it.
Do you think there's a role for morality in law, or morality, or like moral conceptions of the good in how we make
absolutely.
law?
I mean, I think.
How do you know?
I think the very idea that that sexual orientation is irrelevant to how we should judge a person, to how we should view their individual merit, is itself an idea about the proper ordering of a society, individual rights, the limits of governmental power. That is a moral perspective. I mean, that is not. I don't see how
neutral.
It is a moral. It is a particular kind. It is a perspective that says that there are limits to which we can use government authority to impose a moral vision on a group of people. Can we reach into their bedrooms and tell them what to do? Can we tell them who to love and who to associate with, and how to raise their own children and so forth? To what extent can we go? So I think that is in itself a moral perspective. But one thing I didn't mention is the briefing in Lawrence versus Texas itself represents a moral perspective. In this sense, the briefing and ultimately Justice Kennedy's decision do not, in my view, rest on the idea that sodomy laws are unconstitutional because we must tolerate this disgusting, filthy behavior as the price of living in a free society. No. As I read the decision, and as I think it was argued, it says sodomy laws are unconstitutional because gay persons are capable of love and relationships and commitment and family. And the part of it that has to do with physical intimacy plays a role for them, just like it plays a role for heterosexuals in our society. And it's part of forming families and creating a bond between people. That is, it seems to me, a morality. I would call it a neo-traditionalist morality.
And this was in Justice Kennedy's majority decision.
You can see. You can see if you look at the briefs, and you just count the number of times the briefing on the side of Lawrence and Garner speaks in terms of relationships.
That's right. You said it's like 19 times or something.
I forget the word count. It's somewhere in here. It's a lot. I mean, the brief is all about this is part of forming relationships. And then you look at Justice Kennedy's opinion. There's nary a reference to the specific sexual acts that were forbidden by Texas. Instead, it's a decision that rests on the idea that homosexuality or homosexual acts, intimacy between two people of the same sex, can be a good. It can contribute to the good of society. It is good for the people involved. It can be good for our society. It produces better citizens, healthier, happier citizens, and that is, for them at least, a good thing. It's not just a tolerable, disgusting thing, like, we let people burn a flag, but nobody thinks that's a very nice thing to do. It's that this is actually something we should regard as at least good for them and maybe good for our society too.
That is quite an advance.
Yeah.